Hi. So, Christmas, right, was just the other day, but in some ways, Christmas was today. And if you'll look here, if my split screen recording that I'm trying out is working properly, you will see why. Because, you may notice, there have been some new documents in the lawsuit case, specifically starting here with the notice of motion, Memorandum of Law in support, affidavit or affirmation in support of motion from Greg Boser, affidavit or affirmation support from Dax Herrera, an exhibit, which is a screenshot of the podcast on Apple, an affidavit or affirmation in support from Sarah Matz, who's one of the two attorneys. We have exhibits 1, 2, and 3. The first exhibit is the plaintiff's complaint. The second exhibit is the affidavit of service on Boser, and the third is the affidavit of service on Foundation Digital. All three of those documents we've already gone through, although not, myself not knowing all of the facts of the case, as we'll get to. There's some interesting questions, or not questions. There's some interesting problems with those affirmations of service that were submitted by Landau or Maddox or whoever's running the circus over there. I was not planning on doing a video tonight. I did one yesterday, and then Edelman Matz went ahead and filed some late night documents, so here I am. With me is this Balmore 18. Gift from a friend, which I thoroughly appreciate and hope to put to good use tonight. And strap in, guys, because there's a lot of pages to go through, and there's a lot more to come. Okay, so this rundown real quick, and we can start by looking at the first document, which is that notice of motion. This is the notice of motion to dismiss. Right? We expected this. This was the first thought. And this is not an unforeseen move in civil cases. Motion to dismiss comes up pretty frequently. Because if you can get rid of the entire lawsuit before having to argue, you save yourself a bunch of time, money, and stress. But this motion only comes on behalf of Dax Herrera, Greg Boser, and Foundation Digital, LLC. There are reasons why it only comes on behalf of these three. First of all, Edelman Matz is only representing, as far as we know, these three defendants. Baker has not been properly served. Oh, excuse me. Because there has been no filing of an affidavit of service. Same thing with Trevor Burt. We know that Kaufman and... We know that Cope and Patreon are being represented by some other attorneys. We know that Asterios is being represented by other attorneys. Kaufman and Weber Shandwick, I don't believe, have had attorneys respond yet. And I'm going to guess it's because service to them was probably improper. Although I haven't, really looked at it too terribly much. I did one video on service for them. Just on service in general. And it very well could be that service upon them was done in the wrong way. I don't know. Oh my goodness. I got to stop yawning. Anyway, so there's a lot of stuff to go through. But what I was saying is there's a lot more to come. Not to bring up pro wrestling, because, it's pro wrestling, but when they get them and they throw them into the turnbuckle and they just keep hitting them over and over, I would expect that to happen as the dates for answering roll up, right? Each of these parties is going to be answering this complaint, and they're going to be doing it in very similar fashion. yeah, I mean, that's all there is to say on it. So, without further ado, let's just bust into this thing. And I got this cool XSplit casting, recording, whatever thing. So if you got a stupid watermark down in the bottom of the screen there, I apologize, but yeah, I'm not buying before I'm trying. And we'll see how this goes. Let me know in the comments if you can't see the document, if I need to fiddle around with sizes or how I have this set up. But it's got a pretty slick setup here on what I'm capturing, so I'm hoping this is good enough. Sorry, need some whiskey to get into this. And let's go. So, this is a notice of motion to dismiss. This is a notice laying out that they're making a motion to dismiss. They serve this upon all the parties. They file this with the court. And then everybody knows what the main grounds are. What the main motions are, right? And then what the next document that we'll go through is the Memorandum of Law in support of this motion to dismiss. So, please take notice that upon the accompanying Memorandum of Law submitted on behalf of defendants Dax Herrera, Boser, and Foundation, collectively motion defendants, dated January 2, 2018, the affidavit of Dax Herrera sworn to on January 2, 2018 with the exhibits annexed thereto, an affidavit of Boser sworn to January 2, 2018, the affirmation of Sarah Metz, January 2, 2018 with the exhibits annexed thereto. Motion defendants through their undersigned counsel will move this court at the courthouse, room 130, located at 60 Center Street, New York, New York, on the 30th day of January 2018, 9:30 a.m., or as soon thereafter as counsel can be heard for an order. Pursuant, count A, pursuant to CPLR 3211A8, dismissing plaintiff's complaint on the grounds that this court lacks jurisdiction over the motion defendants. B, pursuant to CPLR 3211A8, dismissing plaintiff's complaint on the grounds of improper service of process on Boser and Foundation. And then pursuant to CPLR 327, dismissing plaintiff's complaint as defendants, or as against all defendants on the grounds that New York is an inconvenient forum, obviously. And pursuant to CPLR 3211A7, dismissing plaintiff's complaints with prejudice on the ground that plaintiffs have failed to state a claim for relief. All of these are devastating to Maddox's case. And as we will see, many of them are self-defeating deficiencies in the complaint. I joke a lot about how poorly written the complaint is, but I'm hoping that as we go through this Memorandum of Law, you'll get some attorneys who practice in this area a lot more than I do, and who practice in the state of New York, laying out just how deficient it is. And unlike Maddox's lawsuit, unlike his complaint, they are handy and point to exactly what they're referencing at all times. So, without further delay, let's get into that, because this is the juicy stuff. And as we go, one thing I want you to notice is that this is very nicely laid out. It's well organized. They've included a table of contents, right? Then they've included this nice table of authorities, which anytime they cite an authority and it's listed in alphabetical order, they've provided the page number in the complaint, or in the motion memorandum. In the memorandum where the authority is cited. So here's all the citations. Here's where they're listed. This is extremely convenient for the person who has to read through these documents. And I've said it a couple times in the video, like when you file a 53-page document like Maddox did, and you have no organizational framework to it that makes it convenient for a reader, and Maddox should know this because he's a writer, right? imagine you're submitting a manuscript to an editor, and you're throwing it out there, and you know that some intern who's just been promoted from the mailroom to editor assistant without pay gets to read through hundreds and hundreds of bad manuscripts, right? And if you make it inconvenient or ugly or anything distracting, they're not going to get through the first page, much less the first paragraph. They just throw it out because they have something better somewhere. This is what should have happened in the complaint. It should have been well organized. Not necessarily with a table of contents and authorities. This is a memorandum of law, so it's going to be organized differently. What I'm talking about is citations to the document itself, helping the reader navigate your claims. They just didn't do it. And here, Edelman Mats have done this in wonderful fashion. They've immediately made their document more accessible, more convenient to read. Which one do you think is going to get more attention? When the clerk or judge who's reading this and analyzing these things has to go back to one of these two documents, either the complaint or the memorandum, and they have to find out how they want to frame an issue, which one do you think they're going to look to? Are they going to look to the jumbled mess or the well-organized document? They're going to look to the well-organized document. And what's funny is this document cites to the complaint with regularity and frequency, with specific paragraph numbers, which means that when the clerk or the judge is researching and pondering how this decision is going to go, and they need information from the complaint, they're likely going to look at this document to find the citation for the complaint. It's a subtle amount of psychology, but it really matters. And if you take your time and you're careful and you hire a competent attorney, that's part of the consideration. It's not just throwing arguments on a page. It's also figuring out what the other person looking at your jumbled mess has to go through to support your side. Make it easy for them. Maddox didn't. We'll see if he pays the price in the future. So I'm not going to go through this table of contents because it's just like extra pages, right? Seven pages there. The memorandum starts here on page 8. From this point, it is 25 pages. So we're going to go through it. And a couple things. So I mentioned one, that it's organized nicely. It's very convenient for a reader to go through. But this is helpful for you guys. So there's a process of legal writing that is the accepted method for conducting legal argument in written form. Also in spoken form in a lot of ways, but in written form it's really helpful. These documents get long. Like I said, this is 25 pages of argument, and in going through these 25 pages, you want to have a nice organizational structure as if you were writing a dissertation or a thesis paper in college, right? You want to be able to organize your own thoughts, organize things for the reader. So, in legal writing, that's called the IRAC format, at least in Minnesota. I assume it's called the same thing in other venues, but they may have a slightly different analysis. But it's intro, rule, analysis, conclusion. So you make your introduction, you cite the rule that you're talking about, then you have an analysis or argument about the rule, and then you state your conclusion. If you have one issue, this is very straightforward. If you have multiple issues, like here, I think they address the 8 causes of action that are specifically targeted at these 3 defendants. Then you're going to have your intro section. You can do it a couple ways. You can do intro, rule, analysis, conclusion on each section individually, or you can do intro for everything, and then rule analysis, rule analysis, rule analysis, rule analysis until you get through all of the issues, and then you wrap it up with a solid conclusion. They opted for the second one here. It works really well for them. and let's go through it. Here, we're just going to start. Memorandum of law together with the affirmation. Here's all the defendants, whatever, in the affirmations. Motion to dismiss pursuant to CPLR 3211A8, 327, 3211A7. For the reasons set forth herein, motion... So here I am. I guess I'll use this appropriately. For the reasons set forth herein, motion defendants respectfully request that this court dismiss plaintiff's action against them. Motion defendants, who have virtually no connection to New York and no connection that is relevant to the meritless claims asserted against them, cannot be subjected to jurisdiction by this court. Plaintiffs have failed to allege any facts to support their claims of jurisdiction, despite the fact that proving jurisdiction is their burden. Okay, so again, right off they're setting the tone, how important this is. It's Maddox's job, or his attorney's job, to not just conclude that the court has jurisdiction, but to show why the court has jurisdiction. Whoever wrote that nonsense attempted to do this just by saying that the parties conducted business in New York. But they didn't allege what kind of business. They didn't allege dates of the business conduct, whether it was ongoing or former. They didn't allege the nature of the business conduct. Was it personal? Was it a vacation? Was it a contract for some sort of publication? Was it, did they put on a live show in New York? Did something like that happen? The plaintiff has to allege the facts. Typically, this is easy because you're suing in the venue that makes sense, which is the venue where either two people reside or the venue where the defendant resides, if it's like close to yours but not the same county. For example, you might sue them in their county just to eliminate the issues of personal jurisdiction. Obviously, the county where they live would have jurisdiction over them. But when you don't have that simple go-to, you have to lay out the facts. And they're alleging specifically that Maddox failed to do this. And they're right. He didn't do that at any point. Not only is there no basis for personal jurisdiction under CPLR sections 301 or 302, the exercise of jurisdiction here would run afoul of due process. Plaintiff's complaint is further subject to dismissal based off plaintiff's failure to properly serve two of the motion defendants. Okay, before we get into this, I will say that Edelman Matz have done a fantastic job with apostrophes compared to Landau or Maddox, but they're not perfect, and I will mock them a little bit. Although they get some deference because their document is more adeptly constructed than the complaint. So, like having an apostrophe error, as much as I make fun of them in Maddox's documents, it's funny, but when you've got multiple pages, like, those errors are bound to happen. The frequency with which they occur in Maddox's document is funny, and the other part that's funny is how badly the document is constructed, aside from the apostrophe errors. That when you have something just so grossly, incompetently drafted, having grammatical or syntax mistakes is just funnier. It's more icing. But they do have some apostrophe errors that are going to come up. And as I catch them, I'll probably make fun of them too. Just because it's a thing now. It's a thing. As part of this whole lawsuit, no one can use an apostrophe correctly. This action should also be dismissed pursuant to CPLR 327 based on form of nonconvenience. If you don't get the Latin there, it's inconvenient forum. And if you don't, find a cliff and jump off. Virtually none of the defendants in this case and none of the motion defendants reside in New York. Plaintiffs do not even reside in New York. They reside in California, where Herrera and Foundation are residents, along with several key witnesses. There's absolutely no reason for plaintiffs to have commenced this action in New York. And as there is a more appropriate form available, this action should also be dismissed pursuant to CPLR 327. Lastly, plaintiff's claims must also be dismissed pursuant to CPLR 3211A7 as plaintiffs have failed to adequately plead their claims. As a New York rule, this is known as a 12b6 motion because the Federal Rule of Civil Procedure 12, Section B, subsection 6, is dismissal for failure to state a claim. This is Iqbal and Twombly for the law nerds out there. It's really important that you have specific pleadings that adequately lay out the factual basis for the claims, not just legal conclusions, and say why the court should rule on them, which, as we have mocked, Maddox has not done. As such, and for the reasons set forth herein, motion defendants respectfully request that this court dismiss the action against them. Boom. Done. So that's a solid introduction. Here's exactly what they plan to do in this document. They're going to attack it on this, these sections here. And here's a summary of why. And now they're going to explain it again. And when I said, the wrestler throwing someone into the turnbuckle and hitting them over and over again, you're going to see that in this document. I mean, I was talking in a different context. I was talking about, motion after motion after motion to dismiss are going to come in. They're going to look substantially similar. They're going to have the similar allegations for why this case should be dismissed. But in this claim, Edelman, I think Edelman wrote this, right? Let's see. Edelman Matz. This is signed by Sarah Matz. So we'll just say Sarah. In this motion, Sarah Matz repeatedly hammers the incompetence of the complaint by citing the same sections, the same laws, and the same arguments over and over. And that's a rhetorical technique that you use in drafting legal documents. You say the same thing over and over to cement it in the mind of the person you're trying to persuade. Pretty basic technique. If I say Maddox is a dummy over and over and over, eventually, hopefully, you'll realize that Maddox is a dummy. Again, it's like his dismissal of the broken door fallacy, right? You're a dummy, Maddox. Get over it. So, statement of facts. Back up here. Sorry, I've scrolled up and down a whole bunch, but here we are. Plaintiffs commenced this action on November 6th by filing the summons and complaint. In their complaint, plaintiffs barely allege any connection between the motion defendants in New York. To this end, after acknowledging that the motion defendants reside and are domiciled elsewhere, i.e. California and Nevada, he got Boser's state of residence wrong. Plaintiffs' only allegation relating to New York is the bare bones, unsupported conclusion that each of the motion defendants is conducting business in New York. Unsupported conclusion, right? Conclusory statement, unsupported conclusion, no factual basis, no foundation. See complaints paragraph 3, 4, and 116. This is what I'm talking about. This is where, by laying out the document in a more convenient and accessible manner than Maddox's, when the people want to see, when the clerk or the judge who's reading through or thinking on these documents want to see where a claim is made, they'll probably go to this document, reference those paragraph numbers, and then go to the other document and look at them. Because they'll remember that there are citations for all of the arguments in this motion. It'll be really handy. It gives them, Edelman Matz, an upper hand in controlling the flow of thought for the clerk and the judge. As for the plaintiffs, they're also each alleged to be California residents. See id. Id means previous citation, if you don't know. Paragraphs 1 and 2. Plaintiffs have further alleged without any factual support that this court has jurisdiction over the defendants in this action pursuant to CPLR 301 and 302. See id paragraph 11. Argument. So here's the introduction here. Statement of facts is part of the introduction. The argument is going to do the rule analysis, right? Court lacks personal jurisdiction over the motion defendants. So this is the first element of jurisdiction that they're going to attack. This is personal jurisdiction. So you've got, in legal cases, if I haven't covered this adequately, you have personal jurisdiction, then you have subject matter jurisdiction. So you can have jurisdiction over the person, usually someone who's a resident or domiciled or does business in the forum state. Then you can have subject matter jurisdiction, and that's where you may not have personal jurisdiction over someone, but if you have jurisdiction over the subject matter, you can extend personal jurisdiction through that subject matter. Like, for example, if someone's driving from Maine to Florida, and they get in a car accident in New York, but they don't do any other business in New York, like let's say they even get in a car accident right on the border before they pass out of New York to the south, and the towing company that they hire isn't from New York, right? Like, and everything happens outside of the state of New York, so they have no business contact, they just had an accident. New York is still going to have subject matter jurisdiction because the transaction or incident occurred within the forum's jurisdiction. So the first thing they attack here is the personal jurisdiction. Plaintiff's pleading provides absolutely no basis for the court to exercise personal jurisdiction over motion defendants. Cool. Pursuant to CPLR 3211A8, court may dismiss a cause when it lacks personal jurisdiction over a defendant. And then here they're going to do something that would have maybe been beneficial to Maddox. You don't always cite authority in complaints, but it can be useful to do so. It can be really useful to read the authority, right? Even if you're not going to cite it. On a motion to dismiss pursuant to 3211A8, the plaintiff has the burden of presenting sufficient evidence through affidavits and relevant documents to demonstrate jurisdiction. Coast to Coast Energy Inc. versus GasArc. Okay, really important here, because they're setting it up that the plaintiff has the burden. Plaintiff has to show evidence that the jurisdiction's proper, and they haven't done so with fact, just statements. And statements can be factual, right? Like I could say, if Dick lived in New York, I could say Dick Masterson lives in New York City. He should, of course you have personal jurisdiction. That statement alleges a fact. What they have only done is alleged a legal conclusion, which is that they do business in New York. Well, what business? Do they own a business that has a registered office in New York? Do they have a business that targets New York residents in some specific way? If you don't allege those facts, you're going to lose. Under New York law, this is another quote, the court must follow a two-step procedure in order to determine whether there is personal jurisdiction over a defendant. Court must determine whether New York civil practice law and rule 301 or 302 provide a basis for personal jurisdiction, and if they do, the court must then conduct a constitutional inquiry to determine whether the exercise of personal jurisdiction over the defendant would offend due process pursuant to International Shoe versus Washington and its progeny. So International Shoe is a landmark case. We've talked about it before, and it's the case that sets up the minimum business contacts or minimum contacts sufficient to extend jurisdiction into a forum over a foreign resident. So they're setting up and framing the argument in a specific way here. First, they're saying New York has no personal jurisdiction. Not at all. That there's nothing alleged by Maddox that supports the idea that New York would have jurisdiction over these defendants. But they're already setting up the counter argument of an if by some miracle Maddox produces evidence that would suggest to the court that there is jurisdiction, they then are setting up that constitutional inquiry, the second prong of the test, under International Shoe. Are there sufficient contacts? So then we get to Part A. CPLR 301 does not provide a basis for the exercise of jurisdiction over the motion defendants. Cool. Jurisdiction in New York under CPLR 301 can only exist when a defendant is, quote, domiciled in the state or in an exceptional case where an individual's contacts with the forum are so extensive as to support general jurisdiction, notwithstanding domicile elsewhere. IMAX Corp. versus Essel Group. A, quote, domicile requires bodily presence in that place and also an intention to make it one's domicile. This is just the legal standard for setting up domicile. It's pretty universal. This is from the Will of Chandrell case. Quote, the predicate for this state's jurisdiction over an unauthorized foreign corporation is the fact that it is doing business in the state and thus has created a constructive presence over which New York courts can exact general jurisdiction. Flick versus Stewart Warner. Quote, the court must be able to say from the facts that the corporation is present in the state, not occasionally or casually, but with a fair measure of permanence and continuity. Land Oil Res Corp. versus Alexander and Alexander. If you notice, like almost none of that was original material. They're citing straight to authority, and they're laying out how New York looks at the law, which is something I've suggested that Maddox should have done in his complaint. He wouldn't do it in the exact same way, but he would lay out what these standards are and probably mention why they exist. But he'd at least say there's a two-pronged test for jurisdiction. Here's why plaintiffs or defendants fall into these two categories. But he didn't do that because either he didn't do the research, his lawyer didn't do the research, and if he paid his lawyer and his lawyer did this bad of a job, again I'm going to say, Maddox, look into an ethics violation for your lawyer. But I'm guessing Maddox has not paid his lawyer much of anything. Again, I've gone through this in other videos. I think it was a sign-off. There's simply no basis here for the exercise of personal jurisdiction over any of the motion defendants under 301. Plaintiff has not alleged that Boser and Herrera are domiciled in New York. To the contrary, plaintiffs have alleged that Herrera resides in Los Angeles, California, and have failed to allege any facts regarding Boser's alleged domicile. See complaint paragraphs 3 and 4. In fact, neither Boser nor Herrera are domiciled in New York. And again, like obviously we know they're not domiciled in New York. They've said it several times already, but they're going to keep saying it and just remind the court. These people aren't from here. They don't live here. There's no reason to extend jurisdiction. It'd be silly. To the contrary, Boser is domiciled in Nevada and Herrera is domiciled in California. Which they're, just mentioning that again. See Herrera affidavit paragraph 2, Boser affidavit paragraph 2. There are also no allegations to support an argument that this is an exceptional case where the individual's contacts with the forum are so extensive as to support general jurisdiction notwithstanding domicile elsewhere. Plaintiff's bald conclusory allegations are nothing more than a pro forma recitation of the phrase, the various defendants are, quote, conducting business in New York, end quote, without any supporting factual allegations. See e.g. complaint paragraphs 3, 4, 5, and 8. Not only is this not sufficient to warrant a finding of personal jurisdiction under CPLR 301, it's also not true. Boser has virtually no connection to New York. Boom. Boser affidavits, paragraph 2, 3, 4, and 5. Other than occasional travel to New York that is wholly unrelated to this action, Boser has no dealings with New York at all. Boser affidavit 2, 3, 4, 5. Herrera similarly has virtually no connection with New York. Herrera has only been in New York approximately 3 times for vacation, and his last was approximately 6 years ago. Herrera affidavit 4. Herrera creates, records, and produces and edits his podcast in his home in California. Herrera affidavit 6. Herrera does all the work related to the promotion of his podcast from California. Most of Herrera's relationships are in the entertainment industry, have been cultivated in, and remain in California. See Herrera affidavit 15. Herrera's podcast does not specifically target consumers in New York. Nor does Herrera engage in any type of targeted advertising directly towards New York. Herrera affidavits 8, 9, 10, 11, and 14. Herrera's podcast is available to the general public via internet without regard to location. See Herrera affidavit 6, 11, 14. 6 through 11 and 14. Herrera has never hosted a live show in New York. Foundation, which is a California limited liability company, similarly has no type of constructive presence over which this court could exert general jurisdiction. Foundation has no offices or principals in New York, as affidavits of Herrera and Boser. Foundation does not even have any clients in New York. Herrera affidavit 25, Boser 12. As such, personal jurisdiction under CPLR 301 is inappropriate, and that was very thoroughly argued, right? It's completely inappropriate. There's no reason to support any of this. The plaintiff had the opportunity to do so, and he failed. So that's that. Point B. Court cannot exercise personal jurisdiction under 302 over the motion defendants. There's also no basis for a finding of personal jurisdiction over the motion defendants under 302, A, 1, 2, or 3. As set forth below, none of the circumstances set forth in 302 are supported by plaintiffs' allegations, nor are they supported by the facts. As such, the court should dismiss plaintiff's complaint as against the motion defendants. So again, these are just, Edelman-Matz are just the attorneys for Herrera, Boser, Foundation Digital of the parties who have been allegedly properly served. So they're not asking for dismissals against anyone else. They are not dismissing this case against Asterios or Weber Shandwick or Patreon or Jordan Cope. Just the three named parties. In fact, they're not even dismissing it under Baker. Baker hasn't been served. Not dismissing it under Maddox. Maddox hasn't been served. They don't need to appear. They've had no notice of any of this. Point 1. Personal jurisdiction under 302A1 is not appropriate. Plaintiffs have failed to plead any causes of action against motion defendants that arise from a transaction that took place in New York. As such, plaintiffs have failed to establish that the exercise of personal jurisdiction over motion defendants under CPLR 302A1 is proper. Yep. Quote, in order to determine whether personal jurisdiction exists under 302A1, a court must determine 1, whether the defendant transacted business in New York, and if so, 2, whether the cause of action asserted arose from that transaction. So here's another layer, right? Not only do they have to have business contact, and this is under this section, right? Not only do they have to have a business contact in New York, but then the cause of action has to come out of that business contact or that specific transaction. Lutner versus Homewood Suites by Hilton. Generally, 302A, and just a brief note, that's from 2017. That's a brand new, well, not a brand new, but that's a really new case, and it's useful to assert that, these are the standards that the court is using now, because sometimes you can find citations for stuff that isn't usually adjudicated, and you may go back to like 1890, and that sucks. But it's always helpful to have a nice 2017 decision to back up your case when it's still 2017, or in this case 2018. Generally, 302A1 jurisdiction can be exercised if a defendant's activities were purposeful and there was a, quote, substantial relationship between the transaction and the claim asserted, Fishberg versus Doucette. However, not all purposeful activity constitutes a transaction of business within the meaning of 302A1. By way of example, merely telephoning a single order to New York, requesting a shipment of goods to another state, or the transitory presence of a corporate official. Fishberg. And then they've got a block quote here. Whether a non-domiciliary is transacting business within the meaning of CPLR 302A1 is a fact-based determination. It requires a finding that the non-domiciliary's activities were purposeful and establish a substantial relationship between the transaction and the claim asserted. Purposeful activities are volitional acts by which the non-domiciliary avails itself of the privileges of conducting activities within the forum state, thus invoking the benefits and protections of its laws. Let me translate that for you, because that's using a lot of legal terms. That's from Paterno versus Laser Spine Institute. So availing yourself of the forum would mean that you are personally engaging in actions that would indicate that you're expecting the protection of the forum state. And this is what that business contacts means, right? Because if you do business in New York, and you get, like, if you go in for surgery in New York and they botch the surgery, you'd expect to sue under New York law for medical malpractice because it happened in New York. So you're availing yourself as the plaintiff of the forum. However, if you go in for surgery in New York and would expect that medical malpractice protection, and you skip out on the bill to pay for the surgery, you had availed yourself of the forum, of the protections of the forum in regards to the medical malpractice. So now the forum can exercise dominion over you to collect, on behalf of their resident. It's only fair. If you expect the protection, then you open yourself to liability. That's how it goes. So the argument here, again, is that Masterson, Boser, Foundation Digital, none of them have availed themselves of the protections of the forum. They've not entered the stream of commerce. They haven't invoked the benefits and protections of its laws. Therefore, you don't get to subject them to those laws. They're not there. And not in the sovereign citizen sense, right? Like where they're pretending. They're actually not there. The Court of Appeals has also held that passive websites which merely impart information without permitting a business transaction are generally insufficient to establish personal jurisdiction, Paterno. And that's really critical for Dick's case, right? Because Maddox's argument, which he has not alleged, and this is to his detriment, he has not specifically alleged how this stuff works out. But we can infer logically that he's suggesting that Dick's podcast is consumed in New York by fans in New York. Although maybe not, because then Maddox would have to admit that Dick has fans at all. So, but if that's his determination, that his podcast is available in New York and consumed by New York, just having passive presences by having a generally available content is not typically sufficient to avail yourself of the forum. Okay. We're in Part A now. Motion defendants have not transacted business in New York. Plaintiffs have failed to allege any facts that would allow this court to find that the motion defendants transacted business in New York, and as such a finding of jurisdiction under 302A1 is improper. Again, they're hammering on the fact that the plaintiffs have the burden and they failed to do it. They're not even making comment about whether there's validity to the argument or not. I'm sure, if asked, they would say, obviously, there's no validity. But even if there were validity, the plaintiff didn't put it out there, and that's their job. And it's important to remind the court whose job it is to prove a specific fact or element. Because if you're not required to assist the other party in conducting the lawsuit against you outside of things like discovery and stuff like that. You don't have to make their argument for them. So if they fail in their burden to allege a fact or to introduce evidence, you don't have to do it for them. And you shouldn't. That's why they hire an attorney. That's why they prepare their case. That's why they research laws. And that's the system that we have to make it fair. Because if we start just allowing people to be incompetent, like Maddox is routinely allowed to be incompetent, if we allow that in the court system, we get unfair results by allowing incompetent people to, to win based on some sort of, based on the judge doing the work for them. That's not okay. That's not the judge's job. Judges are to be neutral. In fact, here plaintiffs apostrophe. Come on. Barely pled any connection to New York, and have pled nothing more than canned statements that the various defendants are conducting business in New York without supporting factual allegations. But this is not enough to satisfy CPLR 302, nor is it true. Boser, who currently resides in Nevada and prior to that lived in California, has almost no contact with New York. Boser does not conduct any business in New York, nor does he have any employees, agents, or properties or other contacts here. Other than a few trips to New York for personal reasons to speak at conferences that are wholly unrelated to the claims here, and for which he is not paid, Boser has no connection to New York. Boser Affidavit 4. Foundation also cannot be said to have transacted business in New York. This is good. This is something I didn't know. I thought maybe Foundation would have some sort of contact with the forum, although I think every other claim, every claim against Foundation is nonsense. As there's no, as I discussed in the previous video, Dick has worked pretty hard to keep Foundation out of anything. Even after this lawsuit, he doesn't like it mentioned on the podcast. It is a separate entity. It's a separate endeavor. And, yeah. But I thought Foundation might at least have a client or two in New York, and that might be Maddox's whole plan. Maybe it was, but like everything, he didn't do his research very well. Foundation does not do business in New York, Herrera 25. Have principals who reside in New York, Herrera 24. Have contractors in New York, Herrera 24. Foundation was formed in California, and is run from its principals' homes in California and Nevada. See Herrera 26. Foundation is a digital marketing company and as such solicits business from many places. However, it does not specifically target New York. See Herrera 25. In fact, Foundation does not have any clients in New York. Boser Affidavit 12. I mean, Foundation has less business contacts in New York than anybody else. And that's saying a lot because no one else seems to have any either. Moreover, none of Boser Foundation's even alleged transient connections to New York could confer jurisdiction under them under CPLR 302A1. So this is heading off the argument, right? The counter. Boser and Foundation have no connection to the podcast, and as such, the causes of action alleged could not have arisen from any such alleged transaction. See Herrera Affidavit 21, Boser 8 and 15. To this end, plaintiffs do not even seem to allege the Foundation has any direct involvement with the podcast or the conduct complained of herein. They've only alleged that Herrera gained knowledge from his work with Foundation that he has allegedly used to perpetrate the acts complained of in the complaint. See complaint paragraphs 110 to 116. Yeah, and that's pretty damning. There is also no basis for the court to find that jurisdiction over Herrera is proper under 302A1. Herrera does not regularly transact business in New York, and none of the causes of action alleged arise from any transactions that were alleged to have taken place in New York. Herrera resides in California, where he's lived since 1991. He produces and hosts a podcast from California. Herrera's contact both professionally as an artist and personally with New York State has been minimal, as he's visited less than 5 times, has not been in New York in approximately 6 years. Herrera, so this is a subtle head off. You can say that someone previously had business contacts in New York, but those wane with time. And so they're saying, it's been 6 years, he hasn't even been there. You're outside of the statute of limitations on most things after 6 years, which doesn't matter necessarily. If you're within the statute of limitations on this is what matters. But by saying he hasn't been there in approximately 6 years, you're laying out for the court, even if he had contact at some point, you can't hold it forever. I mean, he wouldn't expect to go back and sue someone in New York, unless that person lived in New York and wronged him somehow. Herrera has established his career as a satirist from his home in California. Podcast itself does not specifically target New York or any other state. It is available to anyone with an internet connection through podcasts on Herrera's website. As a court of appeals held in Paterno, this sort of website is a passive website, which even if viewed in New York does not constitute a business transaction that would permit this court to exercise jurisdiction under 302A1. Succinctly put, they've thoroughly laid out why they don't have personal jurisdiction, and you can tell, the thoroughness of the jurisdiction claim. We're several pages in, and we're not even close to finished with the jurisdiction claim, that it's a crux of their argument. New York does not have the right to haul these guys into the forum. Plaintiffs have failed to allege that the cause of action arose from any transactions in New York. In addition to the foregoing, plaintiffs have failed to allege any facts to support the inference that any of the causes of action alleged arose from any transactions of business in New York, given the plaintiffs, Sarah, have failed to allege any specific transactions that the motion defendants were engaged in that were alleged to occur in New York. Satisfying the second element of 302A1 is impossible, and as such, jurisdiction is improper. Short and sweet. That's an intro, right? So here's the portions to that. First claim is not alleged to have arisen out of any motion defendant's transaction of business in New York. Plaintiffs see, now they're getting tired, and that's how this goes. Have failed to make any factual allegations to support a claim that their first cause of action for invasion of privacy pursuant to New York Civil Rights Law 50 and 51 arose out of transactions in New York. If you remember, this is the first cause of action. I talked about this in a previous video, that you have to, the advertising, the use of a likeness has to occur within New York. Specifically, plaintiffs allege that defendants use plaintiffs' name, photograph, picture, and portrait and or likeness without their written consent within the state of New York for purposes of advertising or trade. Complaint paragraph 118. However, all of the alleged instances where plaintiff's name, image, or likeness were allegedly utilized were via the internet. See complaint 3242 or 3642 120 123. There are no allegations that any alleged transaction by motion defendants in posting any of these images or names took place in New York. To support a finding that the cause of action arose from an alleged transaction in New York. Oh, sorry, that was a comma, not a new sentence. In fact, there is no connection to New York other than the fact that the internet websites that plaintiffs no apostrophe there. There should be. Names, images, or likeness were allegedly available on would have been available to individuals in New York just as they would be available to anyone with an internet connection in any location around the country. Undercutting plaintiff's non-possessive claim to jurisdiction, the only specific instance where the plaintiff's apostrophe... See, now you're getting them backwards. This poor lawyer has probably been ruined so thoroughly by the complaint that she'll have to do therapy to figure out where to use apostrophes from now on. Alleged that Herrera posted one of their images, i.e. an alleged caricature of a Zunian related to the live show in Los Angeles, not New York. See complaint 42. Here there are no allegations that Herrera or any of the motion defendants targeted or otherwise took any action specifically directed towards or in New York. They mean is in, I think. It doesn't matter. This is, I've said this, and I think YouTuber Law said this. What Maddox should have done, I don't know. Actually, I don't know if we said this at all. We probably just said, you got to show how they're in New York. One way to do this would be to get a Maddox fan from New York to sign an affidavit saying they got these advertisements. Right? Like, have someone else support what you're saying, someone who lives in New York maybe. That probably still isn't sufficient, but at least it's something. 2. Plaintiffs failed to allege that their 2nd through 7th claims arose out of transacting business in New York. So they tackled the first claim, which was specific New York statutes, right? Their 2nd through 7th claims are common law claims, so they're tackling them all together. They're not going to go through specific New York law to do that. Plaintiff's 2nd through 7th causes of action similarly failed to contain any allegations that would allow this court to find that they arose out of the motion defendants transacting business in New York. In fact, plaintiff's 2nd through 7th cause of actions do not have a single allegation that even mentions New York. All of these claims, including defamation, misappropriation, intentional infliction of emotional distress, tortious interference with contract, tortious interference with business relation, and conversion, are premised on Herrera's alleged conduct and making statements on his podcast, website, or other social media and online forums with his fans, all of which, even if they were true, which they are not, would have occurred in California where Herrera works and lives. None of these claims have even the slightest connection to New York. As such, the exercise of jurisdiction over Herrera and Foundation is not appropriate. Eighth claim, not alleged to have arisen out of any motion defendant's transaction of business in New York. Sorry, I'm scrolling ahead here. I think what we're going to do is wrap up this section and then call it a night on this video, because this is getting, I can tell this is getting really freaking long. And going through all 25 pages, if I'm reading through this, is going to take a while. So I'm gonna finish up this section. We'll go through here. Just a couple more pages still. And then we'll get to this C section. Actually, we'll wrap up personal jurisdiction. We'll just do point 1 here, and that'll be good for this video. So if you're listening, watching, know that another video is coming tomorrow night. But if I do all of this tonight, it's gonna be several hours long, and that that gets really thick, and I don't want to do that to me or you. Okay, plaintiffs failed to allege that their 2nd through 7th claims arose out of transacting business in New York. Oh wait, didn't I just do this? I just did this. Okay, Eighth claim is not alleged to have arisen out of any motion defendant's transaction of business in New York. Plaintiff's eighth cause of action for deceptive acts and misleading business practices in violation of New York General Business Law 349-350 similarly fails to sufficiently allege facts sufficient. You can tell when like a lawyer's tired of writing because they say allege and stuff like sufficient over and over. To support a finding that it arose out of any transaction of business in New York. This cause of action appears to allege that it has arisen out of Herrera and Foundation's allegedly creating a false advertising campaign. Like lots of allegations here. The only mention of a connection to New York, however, is the bald. They've said bald and baldly quite a bit in here, and I really hope it's intentional. Cheers, Chrome Dome. Unsupported allegation that defendants' action towards plaintiffs' apostrophe have occurred within the state of New York. See complaint section 184. So they even quoted the improper apostrophe. Good job. Herrera and Foundation dispute plaintiffs' allegations in this regard, and in light of plaintiffs' admission that they reside in California, there can be no question that no such alleged conduct occurred in New York. Right? Like, because if the plaintiff and the defendant both reside in California and they don't allege that they were in New York, how can you possibly have this happen in New York? As set forth above, Herrera works and lives in California, and Foundation has no presence or clients in New York. Here, there are simply no allegations that would support the inference that any of the claims against any of the motion defendants arose out of the motion defendants transacting business in New York. The reason for this is also simple. Because none of the claims asserted in this complaint have any connection to New York, nor have the motion defendants transacted business in this state, and as such, the exercise of nor have any of the motion defendants transacted business in this state, and as such, the exercise of jurisdiction is improper here. Again, straightforward takedown of all of the cause of action which these three defendants are named. So, point 2. So, the... and I'm saying so a lot because I must be getting tired. Hence the yawning. The exercise of personal jurisdiction under 302A2 is not proper. Similarly to the above, plaintiffs have failed to allege that any of the tortious acts alleged in the complaint occurred in New York. As such, exercise of personal jurisdiction over the motion defendants under 302A2 would be improper. 302A2, McKinney, provides that, quote, a court may exercise personal jurisdiction over who commits a tortious act within the state, except as to a cause of action for defamation of character arising out of the act. Quote, again, CPLR 302A2 is the long-arm provision that addresses tortious acts committed by a defendant within the state. SPCA of Upstate New York versus American Working Collie Association. So that's a dog case. That's right in that's right in Landau's wheelhouse. Whew, sorry. Here, plaintiffs have simply not pled any facts that motion defendants committed any of the alleged tortious acts in the 3rd through the 7th claims within the state of New York. See complaint 136 to 177. Plaintiffs' conclusory allegations, and see, the reason I mentioned conclusory statements or legal conclusions and why they're using conclusory allegations, like these are trigger words, right? When an attorney hears conclusory allegations, we think to, I mean, you may not get the citation, and I'm pretty sure I have it, but you think back to the Iqbal Twombly standards where you have to lay out a factual basis. You may not remember Iqbal Twombly, but you know that conclusory statements is wrong. So this is a nice mnemonic cue that allows another lawyer to know what you're going for here and getting to these core principles that we know about complaints. So plaintiffs, but there's no apostrophe, and it's getting on my nerves. Plaintiffs' conclusory allegations in the 1st and 8th claims concerning New York are also not sufficient to allow the exercise of jurisdiction under 302A2. All the defendants' alleged tortious conduct occurred online, and none of it, even if the allegations are proven to be true, occurred in New York. Herrera lives and works in California. I mean, how many times have we heard that, right? And there's a reason we keep hearing it. One, because it's true, and two, because it severely undermines the lunacy of having this thing in New York. Boser lives and works in Nevada, and Foundation, which is a California LLC, does not have offices here. It is well settled that, quote, the mere occurrence of the injury in the state certainly cannot serve to transmute an out-of-state tortious act into one committed here within the sense of the statutory wording. Longines Wittnauer Watch Company versus Barnes and Renneke Incorporated. 302A2 does not apply where the tortious conduct takes place outside New York, even though it causes injury within New York. This is Section 87 Tortious Act under CPLR 302A2 from the Siegel New York Practice, Section 87, 5th edition. So that's a practice series. It's a lawyer reference guide on how you handle certain issues, what the prevailing arguments are, and as long as the edition's up to date and there haven't been any overturnings, you can use it as secondary authority, which means it's not controlling for the courts, but it's persuasive for the courts, and you should always cite secondary authority when it's possible and beneficial to your case, and it goes hand in hand with the prevailing authority, which they've done a very good job of citing prevailing authority here, as far as I can tell. Don't practice in New York, so I guess I could be completely wrong, but from what I've seen, Edelman Mats are extremely competent, much more so than whoever wrote the complaint. Here, where motion defendants are all based outside of New York and have no connection to New York that would allow the court to find any alleged tortious act occurred within the state, there's no basis for the exercise of jurisdiction under 302A2. Next point, exercise of personal jurisdiction under 302A3 is not proper. Good subject headings, by the way, laying out very specifically what they mean. Lastly, plaintiffs have also failed to plead facts sufficient to establish personal jurisdiction under 302A3, which states that a court may exercise personal jurisdiction over any non-domiciliary person who's not, a resident of the forum, if he commits a tortious act without the state causing injury to person or property within the state, except as to a cause of action for defamation of character arising from the act, if he, 1, regularly does or solicits business, or engages in any other persistent course of conduct, or derives substantial revenue from goods used or consumed or services rendered in the state, or expects or should reasonably expect the act to have consequences in the state and derive substantial revenue from interstate or international commerce, as set forth in Paterno versus Laser Spine. 302A3, quote, applies where a non-domiciliary commits a tortious act without the state causing injury to person or property within the state. Notice who is not within the state. Maddox. However, the situs of the injury is the location of the original event which caused the injury, not the location where the resultant damages are subsequently felt by the plaintiff. With respect to both subparagraphs 1 and 2, it has been held that the original injury must occur in New York. Maddox's hurt feelings don't occur in New York. They occur in California, in his sad apartment with like 15 other people and one hippie neighbor, who he has probably defamed on his own podcast, and if she listened, she should maybe sue him. No alleged injuries. This is part A of this same argument. No alleged injuries were suffered in New York. In this matter, plaintiff has not alleged. Again, Maddox has failed in his duty and responsibility to tell the court what's going on. Has not alleged that the situs of the injury, i.e. the location of the original event that caused the injury, is in New York. At no point in the complaint have plaintiffs made any factual allegations to support the conclusion that either of them suffered injury to persons or property within New York. The only allegations plaintiffs have made that are even remotely related to New York are pro forma conclusory statements that certain actions taken by motion defendants occurred within the state of New York. Again, just saying it doesn't make it so. You have to say how. How? Complaints 118 and 184, with reference to the first and eighth claims. However, These are not sufficient for a finding of injury to a person or property within New York, sufficient to confer jurisdiction. Sufficient. Told you, tired lawyers. Multiple sufficients, lots of allegations. Plaintiffs here concede that they themselves reside in or around Los Angeles, California. Complaints paragraph 1 2. Only Azunian is alleged to even conduct business in New York, and even that allegation is made in the same conclusory, unsupported manner as all of the other allegations concerning New York. Like Maddox could have just said, I conduct business in New York because my publisher is in New York and I just signed a contract with them. Or, I specifically market to people in New York. That's why I'm there. Nope, didn't even do that. He just said, I conduct business in New York. What business? Do you pee? Pee and poop in New York? Do you make money in New York? Do you make money? Plaintiffs have failed to allege any details as to his connection with New York or how he personally and or through his writing or his online personnel. Like, they even dropped the hint. Like, he could have said this, but he didn't because he's dumb. Or his online personality conduct business in New York. See Complaint 118. Plaintiff Jane Doe is not alleged to conduct any business in New York or to have any other ties to New York. I think they could have stopped at conduct any business. Like, what does she even do to make money? Given that plaintiffs reside in California, it is impossible to make any inference that any injury could have been suffered to their persons in New York in the 1. First claim for invasion of privacy based on the alleged use of plaintiff's name, photos, and likeness. 2. Third claim for misappropriation, which is also based on alleged misuses of their likeness. And 3. Fourth claim for intentional infliction of emotional distress. How could any of that happen in New York if they're not in New York? This is a very good question. I mean, that's not to say it can't. And they're careful here to point out, like, it's impossible to make the inference with the facts alleged. You could make the inference if they told you how it happened. Of course, it wouldn't be inference, right? It'd be deduction at that point. Like, they happened because of this and this and this. I was in New York when Dick made fun of my parents or something. I don't know. Come up with something. I set up a camera in a New York hotel room which was filming my phone that I attached a robot hand to read my Twitter account to get made fun of by Dick. Something. I don't know. Maddox would come up with something ridiculous, I'm sure. Similarly, plaintiffs have not pled any injury to person or property in New York in the 5th and 6th claims for tortious interference with unspecified contracts and business relations that do not have any alleged connection with New York. The unspecified contracts is a subtle dig, and they're gonna recall to this later because, like, to interfere with the contract, there has to be a contract, and the person has to know about that contract to interfere with it. And they don't mention what contracts existed that were interfered with. They just allege that something was interfered with. Plaintiff's 7th claim for conversion of, quote, a variety of documents and virtual information of plaintiffs, apostrophe, sick. They made fun of the apostrophe. Good job, Sarah. I forgive you for everything else. Regarding inter alia Uzunian's fans, sponsors, and business associates, Complaint 172, also has no alleged connection to New York. There is no allegation that any of this property was in New York at any time, nor is there any allegation that plaintiffs own any property in New York, let alone any property that was allegedly injured. Pretty important. To this end, plaintiffs have failed to make any allegation to explain how alleged personal information of residents of California that was allegedly converted resulted in injury in New York. Lastly, plaintiff's 8th claim for deceptive acts and misleading business practice similarly fails to allege injury to a person or property in New York. Now, like, they could have probably combined these, but I think they're very intentional in separating them out to reiterate over and over, plaintiff failed. Plaintiff failed. Plaintiff fails. That good rhetorical technique, man. Plaintiff is a failure. There are no factual allegations to support the claim that defendant's actions occurred within the state. Complaint 184. Nor are there any allegations that New York consumers were injured. That's important. Again, all Maddox had to do was find a fan that somehow could sign off on this injury, and he didn't. Plaintiffs have only alleged that, quote, the material deceptive acts and misleading business practices of defendants were directed at a consumer, defendants apostrophe, were directed at a consumer, which caused plaintiffs apostrophe actual harm. See complaint 185, emphasis added. However, again, plaintiffs have failed to allege how Uzunian, a resident of California, suffered harm in New York as a result of any alleged act by Herrera or Foundation. See complaint 183. Plaintiff's complaint has utterly failed to allege any injury to person or property within New York. Based on this alone, the court should find that the exercise of personal jurisdiction under 302A3 over the motion defendants is improper. Almost done here. B. Neither 302A31 or 2 have been satisfied. In addition, plaintiff has failed to allege any facts that would allow the court to infer that the motion defendants 1. regularly do or solicit business or engage in any other persistent course of conduct or derive substantial revenue from goods used or consumed services rendered in the state, or 2. expect or should reasonably expect the act to have consequences in the state and derive substantial revenue from interstate or international commerce. Maddox had an opportunity to do some of this, and he chose not to. I'm not going to tell him how. I'm tired of telling him how to do things. You failed, and it's probably too late to fix it. As set forth in point 1B, 1A, supra, the motion defendants do not regularly do or solicit business in the state, nor do they engage in any persistent course of conduct or derive substantial revenue from goods used or consumed services rendered in the state. The Boser and Herrera affidavits. None of the motion defendants render services in New York. Additionally, given that plaintiffs are California residents, there can be no way that motion defendants, even if they had engaged in the acts alleged, which they dispute, could have expected to have consequences in New York. And that's evident that everybody is surprised that Maddox chose New York as a forum. As such, jurisdiction under 302A3 is not available. Why did you choose New York? Why? Why? It still doesn't make sense. I mean, if you're scared of anti-SLAPP in California, you should be, I guess, but you'd at least have an argument. Here you don't have anything. Why are you so incompetent? Exercising personal jurisdiction offends due process. Why do you think you are competent? Like, that's the funniest thing and why I stopped liking you so quickly in Biggest Problem. Because I hadn't heard a dick when I started listening to Biggest Problem. I just remembered your website from years ago being somewhat entertaining and having a unique perspective on things. But why do you think you're more competent than anybody else when you're not more competent than anybody? I can't think of a single person that you are more competent at something than them, except maybe, writing from people who aren't writers. But your writing isn't even good. Other people are more competent writers than you. You used to be funny online, and now you're not. That's the only thing I've ever seen a demonstrated competence with you. You're incompetent in fulfilling your own requirements for graduation from your undergraduate degree. According to your own words, you didn't choose to stop. You failed. Like, you demonstrated incompetence. You've demonstrated incompetence in economics. Demonstrated incompetence in basic reading and comprehension skills. You've demonstrated incompetence in reasoning and deduction. Like, routinely incompetent. And now you've demonstrated incompetence in legal process, reasoning, writing, research, drafting. I can only imagine you'll demonstrate incompetence in argument when you can't pay Landau to show up for this motion hearing. And if you do pay Landau to show up for the motion hearing, have fun with that. That's going to be a fun bill. Hopefully you don't have to pay his expenses for traveling from Michigan to New York. Exercising personal jurisdiction offends due process. In International Shoe, United States Supreme Court held that a state may constitutionally exercise jurisdiction over non-domiciliary defendants, provided they had, quote, certain minimum contacts within the forum state, such that the maintenance of the suit does not offend, quote, traditional notions of fair play and substantial justice. Lamarca 95. And then here's a nice block quote from Lamarca. Lamarca, due process is not satisfied unless a non-domiciliary has, quote, minimum contacts within the forum state, with the forum state. The test has come to rest on whether defendants, quote, conduct in connection with the forum state are such that it should reasonably anticipate being hailed into court there. Non-domiciliary tortfeasor has minimum contacts with the forum state and thus may reasonably foresee the prospect of defending a suit there if it, quote, purposefully avails itself of the privilege of conducting activities within the forum state. You haven't demonstrated how anybody has done this. Dick would not expect ever to be hailed into court in New York from his actions, at least from the actions you've alleged. I mean, maybe something's out there, but no one would expect New York. Why you pick New York is beyond me. However, minimum contacts alone do not satisfy due process. The prospect of defending a suit in the forum state must also comport with traditional notions of fair play and substantial justice. See id. Motion defendants do not possess minimum contacts with New York to comport with the standard of due process. Motion defendants have virtually no contacts here. They have taken no actions to purposefully avail themselves of conducting activities within New York. They do not possess the contacts necessary to reasonably anticipate being hailed to court here. Boser and Herrera affidavits. Furthermore, forcing motion defendants to defend this action here does not comport with notions of fair play and substantial justice, where they have taken no actions to direct any of their activities at forum residents. As the exercise of jurisdiction would also offend due process, it cannot be proper here, and motion defendants should be dismissed. In the alternative event that there is any doubt that the exercise of personal jurisdiction is improper here, the party should be allowed to complete jurisdictional discovery. And that's you know, it's the final hedge. They're stating equivocally that there is no jurisdiction in this forum. None. Not equivocally. Unequivocally. Unequivocally that there's no jurisdiction in this forum. But even if the court is like leaning in that direction, they should allow them to complete jurisdictional discovery. In which case, what happens there is that Maddox would then have to provide proof that he has availed himself of the forum, which means that Dick's lawyers probably get their hands on his contract with Simon & Schuster. Ooh, that'd be ugly. Like, have that popularized and publicized. Because that's the only thing I can think of where Maddox would argue that there's, that he has availed himself of the forum sufficient to sustain injury in New York. Then he'd also have to, at that point, he'd have to provide any possible evidence that he sustained injury in New York. And I'm guessing he'd have a really hard time doing that. So it'd probably, it's going to cost Maddox a bunch of money. And then what's funny is that, then Dick would also have to do discovery, which would cost Dick money. But he's going to have to dump all this stuff on Maddox, and then Maddox's lawyer will have to go through it, and that will cost Maddox a fortune. A fortune I'm guessing he doesn't want to spend, because he might not have the fortune available. But anyway, so that's the first chunk of this document. It's about half of it. It's a little more than half. It's about half of the substance, though. Because we're on page 13 of 25 of the substance. And I'm going to end it here. Dick's lawyers, Edelman Matz, are clearly competent, much more competent than whoever drafted the complaint. They've thoroughly laid out their motion argument, and the gauntlet's been tossed to Maddox. Maddox's lawyer is going to have to overcome... Here's the bad part for Maddox. Maddox's lawyer has to overcome every argument of this motion. Because any one of these four major motions, four major subparts of the motion, any one of them is sufficient to dismiss the case. So they have to overcome all four, which means he's going to have to go through and dismantle every one of these arguments. And if any one of them survives and is convincing to the court, if even one, case dismissed against these three defendants. I'm sitting here reading this thing. I don't even know how long the recording is because this is different software, but I'm guessing it's an hour. I mean, I don't know how much Landau costs, but let's say Landau costs $250, $300 an hour. Let's say he costs more because he's in two forums and one of them's New York. Let's say he's $400 an hour. Just reading through this takes an hour. Then you've got all the analysis he's got to go through. He's got to go into the authorities that are all cited here. And if you remember that table of authorities, ooh, that's a lot of cases. He's going to have to read all of them because he's got to find something in those cases to see if there's anything that undermines what's presented. He's got to find out if they improperly cited dicta or if they improperly cited a case that was later overturned. I mean, they have an ethical obligation not to do that, but let's say they made a mistake. Not intent, right? Just a mistake. He's got to go through and try and undermine their argument, and the best place to start is the authorities they cite, because those authorities are similarly going to cite other cases which may have tidbits that are helpful. Hours of time. If this guy costs $300, $400, $500 an hour, this is going to cost a fortune to go through. Or Maddox can do it himself, I guess, and save some money. And that's going to be a disaster as well. So, you know. And then the best part of this is that he's going to have to do it again and again, or Maddox is going to have to drop the suit. Maddox, you sued too many people. You're lucky that Dick has hired the same lawyers to defend several people. You're lucky that he did that. Because had they each filed their own motions, like if each one had drafted a motion, your lawyer would have to respond to each motion. They're already going to have to do it, but there would be significantly more at that point. Buddy, it's not looking good. Drop the suit while you still have money. Because Landau doesn't care how bad it is. He's going to take the cash. You lose either way. The only way you win is if you win. Landau wins whether you win or lose. Because you're just paying him at this point. And, I mean, I'm doing this for free and for fun. Like, Landau is getting paid to do this. I would love to have a case this retarded. I would love it. And to sit here and go through and tear it apart. Most of the cases I deal with are relatively competent. So you got to drop this suit, man. You're going to go bankrupt. And, you know, as much as we think you're an idiot and that you're clearly incompetent, you know, some of us still think we have some fond memories. You know, we have the nice montage running in our head of all the good times when you were funny and before you became just a complete pile of trash. We don't want to see you lose like this. Like, lose because your podcast is bad, not because you dumped a bunch of money into some attorney to file incompetent documents. Or maybe he's going to come out with some miracle. I guess that's a possibility. If you believe in miracles like that, I don't know what you're basing it on, buddy. But you should drop this suit. I said it in the trademark, and I'm going to say it again. Let me save you a ton of money. Drop this suit and save whatever vestiges of your brand are left. Go work on your video game and your pretend other book that no one wants to buy or whatever it is, and just try and salvage your brand. You're killing yourself. You're killing your brand. You're killing your bank. You're making your lawyer a ton of money, and he's not going to win. Not going to win. And even if he does, it's going to be a laughable amount. So, and he won't. Like, that's the ultimate thing. He's failed over and over. He's failed on service. Like, we're going to get to that later in this document tomorrow, when I do this tomorrow. He's failed on service. He's failed on the basic things. He failed on his understanding of service and made you look like an imbecile by filing a motion for default judgment when it hadn't been, when default was completely improper. By a month, by a factor of, I think, 25 days he was wrong. He's not doing this competently. Either you're not paying him enough to do it competently, or you're paying him and he's being incompetent. Either way, he's going to continue sucking down your money for no reason. Why am I helping you? I don't know. I don't know. But God, it's bad. I have a weakness, Maddox. I like to help people. That's my job. Literally, that's my job, is to help people. And I'm trying desperately to help you, but dear God, drop the suit. It's embarrassing. Anyway, tell me if you guys like the split screen setup. Tell me if you wanted me to keep going. Like, I don't know if you guys want a 2-hour video. That seems really long. I don't even know how long this is at this point. That seems really long. I've got another. I mean, number 11's gonna drop. This is coming out tonight. This is number 11. Number 12 is gonna come out tomorrow night, as soon as I have time to record it. And we'll go through the rest of this document and the other two, which are pretty short documents. Tell me if I'm reading too much. Just tell me what you like and don't like. Because there's more of this to come, and I want to make sure and do it in a way that is edifying to you guys and educational. Yeah. Please, by the way, if you're just here for the lawsuit and trademark disputes, check out the other stuff on my channel. You might find it interesting. This stuff's going to dry up. And I love input from people on what they want to see, and I'm happy to tailor the channel to consumers, you know, and just see what you guys want to watch, what you want to learn about legally. If you have legal questions, let me know. Anyway, thanks for watching, guys. I'll talk to you tomorrow.